I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my Chatterbox co-host, Brett.
Hello, Alice. How are you doing?
Don't be sensitive. Don't be sensitive.
Whatever. I'm just taking your insults without, I'm not even going to fight back. I'm just going to take them. You got any more? You want to bring at me, Alice?
So I was trying to come up with a great descriptor, and Brett wouldn't stop talking, and I couldn't think straight. And so I had to shush him for a second. And let me tell y'all, Brett does not take being shushed well.
I don't. And I have to wonder whether these statements that I've made that you're shushing me about can be used against me in some future case.
Was it for the truth of the matter asserted, Brett?
That's a great question. I wonder why that would be relevant.
Guys, you guys are awesome because you are such legal nerds in a wonderful way. You keep asking us throughout this Murdoch trial what hearsay is and what's going on, and you wanted a legal briefs episode to explain hearsay. And that's what we are here to do. It's not the first time we've talked about it, Brett. We were just talking about this. I can't believe we don't have a standalone episode on hearsay because I think we talk about it in so many of our cases.
Well, first of all, I think you're overpromising, Alice. It's impossible to explain hearsay. You can try to explain hearsay, but that's all you can do. There may be some great legal scholar, like off on an island somewhere, like Luke Skywalker in the latest Star Wars movies, who has finally come to understand hearsay as a metaphysical concept. But otherwise, no one really understands hearsay. And that's lawyers, judges, the people who write the rules. We're just going to do the very best we can. So when you're confused at the end of this, just know that generations of law students have left their evidence classes just as confused as you're going to be.
It's so true, because part of it is it's totally a made-up concept, right? This is not how we run our lives. We obviously use hearsay in our daily lives all the time. It's what gossip's made of. It's how you relay messages. It's how you gather information of the world around you. We use and rely on hearsay all the time. So really it is a legal construct for purposes of court. And there are so many exceptions, as we've talked about before, that it's kind of hard to know where all the boundaries are and how you weigh the risks and benefits of what you want to bring in and how the judge will ultimately rule. But with that said, we're still going to try to teach you what hearsay is.
We're going to do the very best we can. And it's funny, Alice, I don't know if you took evidence in law school. Not everybody takes evidence. I think most people don't take evidence, but I did.
Is that true?
I'm a nerd.
I don't know, because I know we make fun of Harvard all the time, but Yale has so few required courses that people look at me in horror when I say I never took X class, because there was just so few classes you had to take, and I didn't have the most fulsome legal education.
Well, surely evidence wasn't a required class. Were you required to take evidence?
I don't know. I don't think I was required to, but I did take it.
Okay. Yeah, we certainly were not required to take evidence. We had one evidence class, basically a year, and 100 people took it, and that was it. And my class, what I remember about it is the final. I remember the final very well, because you do all this evidence, and there's all these issues, and we've talked to you guys about all the different sort of evidentiary issues and character evidence and 401 and relevance and more probative than prejudicial and 404B and all these rules. Our final was just hearsay. It was just hearsay.
Really?
And basically, yeah. And the way the guy did it, and he told us this going in, was there are more questions than you could ever hope to answer. So we had like an hour, and he's like, there's going to be like 240 questions. And each one's a hearsay question, and you have to say, is it hearsay? And if not, why not? And if it is,
that's like my worst nightmare. That type of question and answer about hearsay is my worst nightmare, because I remember as a baby lawyer when I would be sitting there watching someone more experienced in court or in a deposition or something, and they would object to hearsay. I'd be like, what? Why is it hearsay? Why is it hearsay? Which rule is it?
Yeah. And it's funny. And the whole point was you just had to go fast because you couldn't finish, and you just had to get as many as you could. And the idea was you just got to know it, kind of like in a trial. If you get asked a question, you don't have time to think about it or read the rule book or whatever. You just got to go. And that was sort of his theory. And that's why there were so many questions, and it was possible. It was a terrible exam. And we're not going to get you guys where you could do the exam, but hopefully at least this will help you understand the issue. And we get emails all the time from people talking about how something they heard on one of our episodes has helped them understand a case that they're following, and that it's always very gratifying. And hopefully that will happen here. And I think the first thing to mention about hearsay is it's not what you think of when you think of hearsay. So when people use the word hearsay in just a sort of colloquial sense, all they mean is something somebody else said. So when somebody says, well, I heard from Jane that this happened, well, that's hearsay, right? I mean, that's sort of the typical sense of hearsay. In the legal sense, there's some of that. I mean, there's certainly, that's sort of the core idea behind it, but there's more to it than that. And so we're starting in Rule 801 of the Federal Rules of Evidence, if you want to look at this. And the reason we're using the federal rules is, as we've said before, a lot of the states model their rules after the federal rules. So if you're following the Murdaugh trial, for instance, you'll notice they talked about Rule 404B. Now, it's Rule 404B of the South Carolina Rules of Evidence, but the South Carolina Rules of Evidence are based on the Federal Rules of Evidence, so they try and keep that as uniform as possible. It's not always uniform. California is particularly squirmy about this. Their rules are kind of their own thing, typical California, but everywhere else, it's pretty much the same. And even in California, these same ideas continue. So the first thing to know is we're talking about statements here. What is a statement? It means a person's oral assertion, written assertion, nonverbal conduct, if the person intended it as an assertion. So what does that mean? Imagine that, the police say, which way did he go? And somebody points in a certain direction. That is what they mean. That point is nonverbal conduct. They didn't say anything. They didn't write anything down, but they intended that as an assertion of he went that way. And that pointing would be a statement for the purposes of hearsay. So you can already see, even when talking about a statement, how this can be a little bit more confusing than maybe you might think initially. I think initially you would just think, like I said, something somebody said, but it's actually bigger than that.
And you'll see this. I've seen this in like movies or streaming of trials where is asked a question like, well, what did the person do? And they'll gesture like they pointed, somewhere, and you'll hear objection, hearsay. And a lot of people say, but he didn't say anything. That's because nonverbal conduct can still convey a lot.
Yeah, and it is funny how people get around it, and you'll see this some in the Murdaugh trial, where they'll ask things like, without telling me what he said, what did y'all talk about? And so, that's a way to sort of get around it, because you're trying to you don't want the contents of the statement to come in, but you want the person to tell you what they talk about. Now, sometimes that answer ends up being hearsay because it's hard to say what you talked about without saying what they said. But that is the first sort of issue you have to deal with, is the statement. Then there's the declarant. The declarant is the person who made the statement. So whoever it is who made the statement, who wrote something down, the nonverbal conduct, that is going to be the declarant. That can be, by the way, the person who is testifying. And this is one of those confusing things. You can be testifying, and you may have made a statement in the past, and you made it, but you may not be able to repeat that statement on the stand because it might be hearsay. Your own statement can be hearsay under the rules. And what is the rule? So we told you about what a statement is, what a declarant is. Hearsay means a statement, and there are two requirements. One, the declarant does not make while testifying at the current trial or hearing. So that's why your own words in the past could be hearsay, because any statement that's made outside of that courtroom, outside of that hearing, can be hearsay.
And that's why, by the way, police reports aren't just entered as evidence. The police officer has to testify, even if they've previously written something. They can be impeached with that information, but the report itself is not the evidence because it is not their testimony while on the stand at the trial.
Exactly. And that's a big one, because you might wonder about that. We talk about police reports all the time and how important they are. And they got all this information in them. Seems like a great thing to put in at a trial, but you can't because it's a prior statement. And there's other issues with that as well that we're going to get into, some constitutional issues, confrontation clause issues, that even if it weren't hearsay, we wouldn't let it in because we don't want to have this situation where the police officer, the person who is trying to put you in prison, he doesn't even have to testify. He can just put a statement in. We don't want that to happen. So that's one of those things. Alice has put her finger on a big one. That is a statement made outside of the current hearing that can't come in. So that's the first thing. So any statement that someone makes, the declarant makes, while outside of the current hearing. And this is another big one, a party offers in evidence to prove the truth of the matter asserted in the statement. So it's
I know
any
a lot
statement.
Of you guys are shaking your heads because you're like, what? Those are just words. What do you mean by that?
Yeah. And look, it's pretty straightforward. I mean, it's not straightforward, but let's make it straightforward. It's a simple case. It's a car wreck case. And the only question is, what color was the light? Was the light green or was the light red? Somebody's being sued for running a red light. Obviously, whether the light was red or not is important. And let's go back to that police officer. Let's say the police officer is there at the scene and there's a person and he's writing in his little report and the person says, I saw the light, it was green. Okay? Now, the defendant, the person who's being sued, he's going to want to get that statement in to prove that the light was green. But it's an out-of-court statement made for the truth of the matter asserted. So therefore, it's hearsay. He cannot rely on that statement. He needs that person to come in and testify at the hearing and say, I saw the light, it was green. That person needs to repeat that statement. Now, why is that? What is the point of all this?
The reason, if it's for the truth of the matter asserted, to say what the color of the light was, you need to be able to test them because you need to be able to cross-examine them. Where were you standing? How good is your eyesight? Do you wear contacts or glasses? Were you wearing contacts or glasses that you were prescribed that day? I'm going to stand to the back of the room and hold up 3 fingers. How many fingers am I holding up? You can't even see that. How could you see the light? All of these questions to basically test whether this person could have conceivably seen what they've seen, and to push, this is why we've talked about direct evidence being the exact same weight in the eyes of the law as circumstantial evidence, and sometimes direct evidence isn't even that good. Listen to all those questions I just asked about, the person's ability to see, and obviously extrapolate that to something much more complex than just seeing the light.
I mean, look, at the end of the day, this is about the adversarial system. This is about bringing everybody together into a courtroom and having the statements and the evidence challenged, having the people have to testify, having people have to confront the person they're accusing, all those things you think about when you think about what's a fair trial. I mean, that is one of the big reasons you have hearsay. And in many ways, hearsay is the most important thing, right? I mean, it's one of the most important rules because it prevents that so much. And I'll give you an example from this trial. I mean, just sort of somebody asked about this on the gallery. There was a weird situation. One of the weird things about this case is the lawyers for Murdaugh are like this close to being witnesses at various points in time because they were doing stuff throughout this saga that puts them kind of in the crosshairs of being witnesses. One of them is Jim Griffin, who's one of his main lawyers, the one who does a lot of the talking, who's not Harpootlian. He called Marion Proctor, who was Maggie's sister, and told her that Alec had been shot on the roadside in September. And at some point, the prosecution is wanting to ask her about that, and Griffin actually objects. And he says, this is hearsay. She can't testify to it, which is really kind of crazy, right? Because you got the lawyer objecting to the fact that this is hearsay, which my immediate thought was the prosecution should have been like, okay, fine, we're going to call him as a witness. If he's going to object to the statement and we can't get it in, then we want him to testify. They didn't do that. And I think at the end of the day, I think it was sustained. But the whole idea was, look, they're trying to get my prior statement made outside of the court in to prove the truth of what I was saying. That's why they're doing that. And so it can't come in. And that was the source of the objection. And it seems strange to people because it's literally someone standing in the courtroom objecting to the introduction of his own statement. But it fits within the rules. The big thing, though, the big thing about hearsay is That seems really clear. And we've waved the flag and the national anthem's played and fireworks been going off about the right to confront people and how we want to bring everybody together and we don't want all these outside statements coming in. As clear as that seems, there are so many exceptions to it. And
I mean, this is the beauty of it. Go look up the federal rules of evidence. We had an episode where we did a live show and Brett pulled out the rules, and it was a code book, but people went crazy for it, Brett. I don't know if you saw the comments on YouTube, but it was really, really sweet. People were like, please read the whole thing, Brett. Well, if you go pull out the rules of evidence, it is helpful to see it, because when you look up Rule 801, the definition of hearsay is like, I don't know, 4 lines long. The exceptions to what is not hearsay spans pages upon pages, single-spaced. And this is what we're talking about and why hearsay is so complex. Not because of what the definition of hearsay is, but because of what it is not.
We're going to spend a lot of episodes on this. This is not going to be a one-episode thing, because as Alice said, there are so many exceptions to this, and we're going to go through them. And I think we'll go through all of them, because why not? And then by the end, you guys will all be able to pass the bar exam in your state. So we told you what hearsay is. It's an out-of-court statement made for the truth of the matter asserted. Those, like Alice said, they sound lawyerly words at first, but I think once you kind of get it, you get it. Like, you can't use somebody's statement from outside of court to prove something in court. You just can't do that. And there's the rule against hearsay. So that's 801. 802 is the rule against hearsay. So 801 defines it. 802 tells you you can't use it. Hearsay is not admissible unless any of the following provides otherwise: a federal statute, these rules, or other rules prescribed by the Supreme Court, because the Supreme Court can make rules of evidence outside of all the other stuff it does. So you've got this rule. You have this very neat, tight definition of hearsay, which would seem to mean you got to bring everybody in, got to have them testify to what they saw. And then you basically have an exception, which in many ways completely swallows the rule and says, yeah, we have this rule, but here's 1,000 exceptions to that rule that's going to allow these statements to come in.
Before we get there, though, let's talk about a couple statements that just don't fall into hearsay at all. Because this is what was confusing to me as a law student and as a baby lawyer, was that there's exceptions to hearsay, and then there's definitionally things that are not hearsay at all. And we've talked about both, and I think understanding at least the basics of what is not defined as hearsay at all is helpful. One thing that we've talked a lot about is the admission of a party opponent. So the other side, it's a statement offered against a party. And so if Murdaugh, that's why, by the way, all of these initial interviews and, times that Murdaugh has talked to the police can come in, because it's the admission of a party opponent.
Yeah. And Alice says admission because that's the way it used to be. Now it's not even admission. It's just a statement.
A statement.
So any statement a party opponent makes comes in. So anything that Alec Murdaugh has ever said is not hearsay. Doesn't mean it might not get blocked by some of the other rules, right? So there's relevance. It has to be relevant. It could be 404B evidence. 403 might keep it out because it's unfair, but hearsay is not going to keep it out. And in fact, as Alice said, it's not even hearsay. This is not an exception to hearsay. This is a statement that by the definition we have decided is not hearsay, even though it's made outside of the court and is offered for the truth of the matter asserted. Even though definitionally it may appear to be, we've added exceptions to the definition itself. And this, like Alice said, this is really weird, because we're going to talk about exceptions to hearsay in a minute where hearsay comes in. But this is like the pre-exception exceptions. And they're some of the biggest. I mean, this is
huge.
Massive.
I mean, this is really massive. And here is one of the huge reasons you always hear the advice, don't talk to the police without an attorney, is because if you are on the other side of the V, anything you say when the police give you your Miranda rights can and will be used against you. This is part of the reason. If you are a party opponent, just meaning you're on one side of the V, then anything you say just falls outside of hearsay. Of course, there are other rules, but the hearsay is kind of the big blocker, and it's kind of the go-to rule to keep statements out of court. And you completely lose that defense, I guess, the ability to keep statements out when you are a party opponent.
And it's even bigger than that, because it's not just your statements. It can be things that you manifested, quote, you adopted or believed to be true. So someone else could say something and a reporter asks you, did you hear what John said? And you say, sounds right to me. Well, then all of a sudden his statement can come in against you because you said you believed it to be true. There's also statements made by someone you've authorized to speak on your behalf. So if you hire a firm, a communications firm to be a spokesperson for you, and your spokesman just goes off the reservation and says something really harmful for you, doesn't matter. You authorize them to speak on your behalf. It's not hearsay anymore. Your agent, if you have an agent, and this can be really important in civil litigation, an employee. If there's an employee who has sort of special authority in your company and they speak on your behalf, they could bind the entire company and really get you in a lot of trouble with liability.
And you can imagine with that one, someone like Alec Murdaugh has a lot of agents, right? I mean, he works at a law firm. There are people who work at his law firm who are affiliated with him. He has housekeepers. He has people who work his land, people who take care of his dogs. I mean, just in terms of the people who are surrounding him who may have agency to speak on his behalf, broadens the number of people who could be defined as a party opponent for purposes of not hearsay. And so this comes in huge, and this really comes in huge liability-wise for a company, like Brett just said, which is actually at issue here because of the law firm that he is a part of.
And look, your lawyer can be one. If you have a lawyer who's like spouting off to the press on your behalf, that can cause you a lot of problems under this rule. I think you saw that in the Johnny Depp Amber Heard case. I think one of them, I can't remember which one, ends up being liable for something their lawyer said at some point. I think it was Johnny Depp. I think Johnny Depp might have gotten hit for something his lawyer said. That thing came in because, his lawyer represents him. And that was within the scope of their employment. So that can really affect you on the civil side. And then on the criminal side, you have co-conspirator statements, which can also hurt you. If you have a co-conspirator and they make a statement and it's in furtherance of the conspiracy, that statement can be one that causes you a lot of trouble. Now, it has to be during and in furtherance of the conspiracy, which keeps out your co-conspirator's confession. So if your co-conspirator gets arrested and confesses, that is not going to come in under this hearsay rule. And there's also some Supreme Court cases that will keep it out. But that's the big exception that Alice identified. Anything that you say or the people sort of associated with you say isn't even hearsay. It's specifically excluded from the rule. Another one that we talked about in the Ralph Stokes case is a prior consistent or inconsistent statement. So one of the big things that you'll see in trials is someone makes a statement and then on cross-examination, the defense will stand up and say, now, didn't you say 3 weeks ago in this other thing that the opposite is true of what you said today? And you might think, well, that's a hearsay statement. That was made outside the court and is offered for the truth of the matter asserted and all this other stuff. Well, it can come in, and there's two circumstances in which it can. The first is when it's inconsistent with the declarant's testimony and was given under penalty of perjury at a trial, hearing, or other proceeding or in a deposition. So there's going to be some gloss on this later on, but for our purposes right now, if it's inconsistent, it can only come in if you testified previously under penalty of perjury. So if you were at another trial.
You can understand why that is, right? Because you're trying to compare apples to apples. You're on the stand and you're under oath and you're speaking. And you should only be kind of confronted with an inconsistent statement if you were also under the same obligations to tell the truth. Because we can all imagine if you're just talking along the soccer sidelines to like another parent, you may stretch the truth or embellish your story, and you shouldn't be held accountable for an inconsistent statement in that situation. But comparing apples to apples, you've taken an oath to tell the truth. And when you took that same oath, you said something different. That's apples to apples and why you can compare those statements.
And I'm gonna mess with your brain a little bit here. So prepare your brain to be messed with. The reason this is important is because this is an exception to hearsay altogether, which means if you have this circumstance where someone testifies and they have to be in trial, as Alice said, it has to be apples to apples. So let's say that there's a hung jury in this case, okay? So hung jury in this case, and we have to try it again. And they put someone on the stand, and that person in trial 2, they testify. Okay, now you've got the person testifying in trial 2. They testified in trial 1. So you have the apples to apples comparison. And what will happen here is in the second trial, whoever is on the other side, whether it's prosecution or the defense, they get to introduce this statement, and it's not just to undermine you. It's not just to call into question your credibility. If you're putting a prior statement in for that reason, that's a different exception altogether. If you just want to show that the person testifying said something inconsistent before, and therefore you shouldn't necessarily trust what they say now, there's a lot of statements that can come in. But in this instance, you can use that prior statement not only to undermine the person, but as evidence for the truth of the matter asserted. You can use that prior statement to prove your case, which is something very different from just undermining their credibility. And it's a nuance, and it's one that confuses a lot of law students, but it's a really important one because it's a very powerful thing if all of a sudden you can prove your case with prior statements.
Which is so big. And we've talked about this before, why there are a lot of factors to consider if you get a mistrial or a hung jury, whether to try the case again. You've basically had all of your witnesses testify under oath already. And it's really hard for any one person to say the exact same thing, especially when you have cross-examination and it's not a script you're following, right? Even if you've prepped your witness, when you're in trial, you're reacting to questions and your answers will be a little bit different each time. You can imagine that you kind of get in a fraught situation when the other side has just hours, weeks, maybe months of testimony that's already under oath that could potentially be used as truth of the matter asserted. And we've also mentioned this in the context of grand jury, where you usually have a case agent or a law enforcement officer testify to your case to make the case for the grand jury for probable cause, or you have other pretrial hearings where you need to call law enforcement officers. There's strategy in who you call because you somewhat want to limit the number of under oath statements in court you have for your different law enforcement officers, because the more testimony there is, the more you get into the territory of what Brett just described, of potential inconsistent statements that could end up helping prove the case for the other side, even though they are out of court statements, even though they are not what is being said on the stand at that time.
And this can be an important strategy for prosecutors. As Alice said, you're always wondering about who you put in because, if you put your main officer in the grand jury and they make a bunch of inconsistent statements, that can be problematic for you. But the other thing you do is you may have witnesses who are problematic and you're worried about what they're going to do at trial. And you're worried that by the time you get to trial, they may change your story. If you put them in the grand jury, they are under oath, under the penalty of perjury. They're in a hearing or other proceeding or in a deposition. And what they say in that setting can later be used in trial if they don't testify the way you want them to. So take an example where you have someone who, it's an abuse case, domestic abuse case, and you have the partner and they've been abused, and you put them in the grand jury and they say everything that happened. They say all the ways they were abused. And then by the time you get to trial, they've completely changed their story. Now they're saying it never happened. A lot of times that kills your case, but more and more jurisdictions are trying to push forward because these are so dangerous. We just see so many times where people, they drop these charges and then later on even more horrible things happen. So more and more jurisdictions are trying to press forward and win even with an uncooperative victim. When that circumstance, if they get up on the witness stand and they say never happened, none of it happened, you can confront them with this testimony and then all of a sudden it's evidence. So you can use it as evidence to prove your case, which you would not normally be able to do. So that can be really important, who testifies in grand jury and who doesn't.
And that's a great point. We call it like boxing in a witness. It can be kind of in the sympathetic sense, like a victim who maybe will become scared and not want to testify against the perpetrator later on. And some of you may be thinking, but who's going to believe them when the person is sitting on the stand and they're saying, no, I never said that. There's a way to kind of confront them with inconsistent statements. That's not just what you see on TV where, the hard charging prosecutors like banging them over the head. Like, are you saying you're lying now? You have to read the room. For a victim like that, you could very well make them sympathetic and kind of draw out the fact like, have you ever been scared of defendant X? Are you scared of him now? I see that you haven't looked at him this entire time. Is there a reason that you're afraid to look at him? Is there any reason that you would not want to say this now? There's ways to basically convey to the jury what she said earlier. That was the truth when she was sitting in a room that did not have the defendant there staring her down, and she felt more free to say what actually happened as opposed to right now where he's boring his eyes into the back of her head and maybe mouthing like, I'm going to kill you. And you can see how that would be really powerful evidence, even though your witness is saying the opposite on the stand. But the other thing is like people get shifty later on, especially when we've talked about this in the Murdaugh case. The Murdaughs are kind of known for tampering with witnesses. They want to coach their friends who are potential witnesses or friends or witnesses in their cases about what to say. And so before they are basically gotten by whoever's going to coach them, you get them to sit in grand jury and say what is closer to the truth than what they'll be coached to say later. Or like you catch, a parent who in a moment of honesty wants to tell you everything that's true in the grand jury, you lock them in so that by the time trial rolls around, maybe they're like, I don't want to send my son to prison for money laundering. I'm going to lie about how he used, my name to launder money. But previously the mom may have said the truth in grand jury. So there's different ways of boxing in your witnesses and using it to your advantage because people are shifty and prosecutions take a long time. It's not like you put someone in a grand jury and you're going to trial in the next month. There's usually some amount of time that passes. And during that amount of time, people's minds change, their own risk analysis changes and how they, what side they want to be on. And all you want to do is get to the truth.
So we haven't even gotten through the main rule yet. We're going to get through the main rule. The exceptions are going to have to come next time. But so that's inconsistent with the declarant's testimony. You can also use prior statements that are consistent with the declarant's testimony. Interestingly, if it's consistent, it doesn't have to have been given under penalty of perjury in a trial hearing or other proceeding or in a deposition. But there are other limitations on it. So let's say you've got someone who's testifying. Let's just continue with Murdaugh trial 2. They're testifying, and you want to offer a statement that they made previously outside of court that is consistent with what they're testifying to now. When can you offer that? Well, there are really kind of 3 situations in which you can do that. The first is to rebut an express or implied charge that the declarant recently fabricated it or acted from a recent improper influence or motive in so testifying. So that is basically, we saw this in the Ralph Stokes case. You had a witness who testified, and on cross-examination, the defense basically said, isn't it true that your story has completely changed since when you talked to the police? And isn't it true there's a reward involved here? Basically, the defense attorney is accusing that person of changing their story recently for an improper motive. Then on redirect, the prosecution gets up and they say, I want to read in his prior statement for the record. And they can do that because it's a consistent statement of what he's testifying to now, and because of this door getting opened here by what the defense asked, that prior statement is also evidence of the truth. So in that case, the prosecutor basically read everything this person said to a police officer much closer in time to the case, something that ordinarily would not be admissible now is admissible and can be offered for the truth of the matter asserted. So that's the first exception. Or to rehabilitate the declarant's credibility as a witness when attacked on another ground. This was added because people tried to get in statements that were made previously where there was a memory problem. It might just be a typical memory problem. It could be something more serious like dementia. And you'd have someone who would testify and the defense would get up and say, isn't it true you have trouble remembering things? Isn't it true that sometimes you forget things? And that's a perfectly legitimate attack. This first exception, though, did not allow that prior consistent statement in because you weren't accusing them of anything improper. It's not improper to not be able to remember things. And so eventually this second rule was added so that you could bring in that prior statement when a witness is attacked for something like memory.
Sorry, y'all confused yet? Because clearly we're going to need a whole nother episode, at least one, maybe two, on the exceptions. But I think this gets you at least part way to make intelligent statements to friends about what is and is not hearsay. And that actually gets you a lot of the way there.
And this is a lot. I mean, these are huge exceptions that we've just laid out. But I got to tell you, there's like 40 something more. I mean, these aren't exceptions. I have to say these are exclusions. I think is the way we say it, because these things aren't hearsay. They are not hearsay. You don't need an exception because they aren't hearsay. So if you make a hearsay objection, you basically say, Your Honor, it's not hearsay because it's the statement of the party opponent. It's a inconsistent statement made in the last trial. I mean, something like that. It's not hearsay. And the biggest one that's not hearsay, we've already sort of laid out for you, but it's not laid out in the rules because it's part of the rule, and that's that it has to be made for the truth of the matter asserted. And a lot of statements come in because you're not really trying to get to the truth. You're trying to sort of build the scene. You're trying to show what people were saying and what people were thinking, like...
So, for example, if a dog runs by... And people will say, and I'm using a very simple example that doesn't have to do with any evidence to hopefully make it easier. A dog runs by and you want to get in that someone said, whoa, look at that wolf. You're not trying to let in that statement to establish that whatever ran by was a wolf, but to show maybe the size of the dog, maybe why people started panicking because they thought it was a dog. And you'll hear that a lot where the attorney who is being objected to will say, well, we're not offering it for the truth of the matter asserted. The issue there is, as human beings, it's hard to kind of separate those two. When we hear words, we tend to want to take them at face value. And so it's kind of, again, one of those legal constructs.
And I'll say this is a huge exception, and it should be a huge exception, but in courts, this argument fails more than anything because so many judges are under the misconception that, well, it was a statement he didn't make here, so therefore it's hearsay. If he's not here making the statement, that's hearsay. So unless you got an exception or exclusion, it's not coming in. And they forget about this part altogether. Or even when you make this argument, they still sustain it as hearsay because they just don't get it. Because frankly, this is a rule that so few people understand in all its complexities, to the extent there have been a lot of discussions about getting rid of the hearsay rules altogether and just making it kind of like 403, where it's a balance. It's, 403 is the rule that says it comes in unless it's more unfairly prejudicial than it is probative. And some people want to make hearsay like that. It's hearsay, but it seems pretty important and it's pretty reliable, so we're just going to let it in. And a lot of people want to replace all these rules with that because the rules, there's so many of them and they're so confusing and no one really understands them. So far, that has not happened. This is one of those things. Hearsay and the rules in hearsay are so precious to lawyers, and so many people have spent so long learning them and use them. And it's one of the reasons they're good at their job because they know the hearsay rules, that they don't want to let go of them. So I don't know that the hearsay rules are going anywhere soon.
Well, Brett, I love talking about this with you, and we're going to have to save the exceptions, so things that are hearsay but are allowed in because of an exception, for next time. But before we sign off, Brett, do you have anything you'd like to add on hearsay?
Well, I don't want to add anything I've said before because, if I said it in a previous episode, I don't know if I can use it in this episode because that might be hearsay. So I'm just gonna stop while I'm ahead and not confuse people anymore.
Thank you guys for joining us, and thanks for asking these really great questions. You make legal briefs so fun and so engaging for us. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
We'll just do
Have we
hearsay.
not talked about hearsay?
We've talked about it in the prosecutors, but not on Legal Breeze.
Okay. I forget what we talked about.
We talk about it all the time, but we don't have a specific set of episodes that people can go to and be like, hearsay.
Okay, let me think of a good descriptor for you.
So we'll do this. We'll do like 30, 35 minutes. I mean, just a typical one, not like the super long ones we've been doing.
Yeah.
Then we'll just stop wherever, and then we'll pick up, after the
stop
baby.
talking for a second so I can think of an awesome descriptor for you.
Sorry, God.
I'm just trying to think of a great
Alice.
descriptor.
Talkative, I guess. Won't shut up, co-host.